Now, let me try and tilt us back to the basics. Once you know what you have, you know what risks you are taking. You can then tell your client, go ahead. Now, even though you do a search, you finish with the land registry. Now, for title documents, you finish with the land registry. Oh, it has title. You still have to go further and go to the lease pendings registry. This is linked to the High Court system now. You must have your active account, you must have a register, and then start typing in the name of parties to that document you're looking at, name of landowning families to that area, or the name of the area, and see if by chance there's any litigation over that piece or parcel of land. For large pieces of land, it may be a small section that is under litigation, so it may not affect the area you're buying. You may not see anything. But once you see anything, that's a red flag. So you ask questions. I saw this. What is it about? The seller has to tell the buyer that, okay, no, it does not concern me. Okay, give me that one. I want to see it. Then you still further again go to the courts where those documents are, and conduct a search on the court documents to know that indeed the area they are fighting over does not concern your client before you now give the client go ahead. There are so many levels to it. Now, the search is the basic thing you must do. Now, what then are the documents you will encounter in your real estate journey? The clients, I'm trying to think from both the realtor's perspective and the general perspective of law practice. The client will ask the realtor, what title does he have? The answer should be, it doesn't have title, but it has title. Please note, the survey plan, a very integral document to title, but it is not title.
Can you?
Please note, a survey plan, a very integral document to title. It itself, from the legal point of perspective, it is not title. All right. So, a survey plan will describe your land, will tell you where the land is, with the coordinates on it. Surveyors can take you to the land. For those that have the patience to convert on Google, there are free conversion tools to convert to longitude and latitude. You can take coordinates on a survey plan, put it into those converters, and it will give you longitude and latitude that you can drop on your Google map and drive to that location. If the location is what that you are, you can suffer. But the survey plan describes everything about the land. Tells you where it will be located, can take you there. It also tells you if it's registered or not. I won't really be going into that and all that, but for any title document, the survey plan must have been registered before that title document can come into existence, because there is no title document that does not have a survey plan attached to it, or the workings or markings that make up a survey plan, making numbers, pillar numbers, and so on and so forth. Now, I mentioned that because I want people to distinguish the fact that a survey is not title. But at the end of everything, this is just a snippet from being in the real estate industry and working with realtors for a long time. You speak the language your client understands. If your client is saying, does he have survey? That's survey. If the client is, yes, it has a survey, you will still get your own survey for your own plots or plots. You understand that kind of a thing? Just speak the language your client understands. Don't be too technical. Have their understanding. So when you meet that client that wants it broken down, you can break it down for the person. Now, aside with the survey, because it's one of the basic things before you have any form of title. Now, let's move up from the survey plan to one of the most popular documents you will get in real estate, the deed of assignment. Now, I'm going to use a word before that deed of assignment to distinguish it. Now, most people that carry their deeds of assignment, most of the time are not registered. because a lot of people out there are advanced to wanting to pay corporate money. So you just say, I'm collecting my deed of assignment and they go to sleep.
So a deed of assignment
it needs to be registered to become perfect title. Now I'm going to use this example I love giving about a car. So Mobolaji buys a car. Let's say a Range Rover. She will look good one. So you buy a Range Rover. So you buy it from the dealer, right? You don't register the Range Rover. So maybe you're driving to Oyo State, for instance, and you get stopped by the police. Madam, you look fine. No, I beg. Madam, please, can you show us your documents of ownership of this car? You now have to start explaining that I bought. That is where your receipt comes into play. Okay. You have your receipts showing that you bought it from the previous owner, who is the dealer. But there is no other paper apart from receipts showing that Omobolaji. They'll say, where's your proof of ownership? You'll be like, I don't have it.
I have receipts now.
I have it. It's not. You are driving in the old, technically speaking, or in legal, not in legal balance now, in street balance. That car is still in the name of the former person. That person can come and claim that car from you. Can does not mean they will, because probably the way receipts are done, it shows that both of you have exchanged. Exactly. So until you register the car in your name, that the government has evidence of it. Because nowadays, it's not just the car alone that is registered in your name. Your plate number will be registered in your name, will match your plate number. Once they scan nowadays they scan the plate numbers. So once they snap your plate number and it's scanned into the road safety app, it brings out all the information of the owner attached to that plate number. It'll tell you the make and model. That plate number was issued for this vehicle. So if you were using that, maybe you have 5 cars in your house and you said, maybe you saw one plate number is lost and you went to go and put the plate number of your Volvo or the plate number or your. They will scan it and say, madam, how far now? What are you trying to do? So now remember what I said, that the government is the one that has everything you want to do is done with the government. So you own the car. The dealer is not going to come and drag you. But until you show paper by the government to anybody to say, I own the car, everybody is going to say, you are not the owner of the car.
That's true.
So until you go to register your deed of assignment with the government or submitted it to issue a COO for those that have deeds of assignment from homeowners in lands that are free from government acquisition, and they give you a COO, the government will. The only time your document becomes perfect is when the government has registered it for you. So back to that word, deed of assignment. The deed of assignment is just basically a record of a transaction for land. Now, this is legal, strictly legal by law, right? Any transfer of interest in property must be by deed, in a deed format, meaning it should have the name of the parties in the transaction, meaning there must be a part or portion or recital, as we call it, that shows the history of that property till date, from foundation. Sometimes there are history recitals that are up to two pages because of maybe a transfer that, a lot of transfers that are done on in that place. You understand? Then you must have what you call the clause that talks about money or consideration. You cannot have property transferring from one person to another without some sort of consideration. Now, consideration does not have to be money all the time, though. E.g., if in my lifetime I want to give you a gift, or your dad wants, let's do that, a transfer of title, or rather property, from one person to the other must be by what? Deed. I've said that, right? So he's going to give your dad in his lifetime not to say, okay, Bolaji, before you get married, though, I want to give you this 5 plots of land at Lekki. He's going to prepare a deed of gift and give it to you.
Okay.
So the format of the transfer will be by deed. The consideration is as my loving daughter. This is not like you inherited it, so we're not talking about will now. We're talking about a deed of gift in your dad's lifetime. He is alive. Yeah, I said, look, I don't want your husband to bully you. Bolaji,
5 plots.
5 plots in Lekki or 5 houses in Lekki where you are earning some crazy rent per annum. You understand? So even if it's shakara, you just you are no rent. You say that thing. You understand? Now, so the consideration can be for money, the consideration can be for anything. I'm just it's my friend or I'm happy. This is a deed of gift doesn't have to be father daughter or father son or something. It can be me giving land to my friend. It becomes a gift because I am not collecting money. Now, then there will be other clauses that talk about different things, e.g., whether there is a right of the owner to come back to own that property or not. And I'll get there. I will mention the one that is. Let me just mention them. Leases and sub-leases are the ones that give rights back to the originator or original owner to own it or not. Now, for most deeds of assignment, the word itself says that I am assigning my rights and interest that in this property. So I am not taking it back no matter what. I am giving all my rights to this property forever. So you are extinguishing your rights. That is the person selling it. Now, of course, it must have an execution clause. It may or may not have a schedule, but to me, it's inelegant drafting or inelegant drafting only. There's no other word I can use beyond drafting. It's inelegant writing on a document to not have a schedule that explains that, okay, all the plenty talk we don't talk since. So this is the schedule showing that block 2, plot 5 with survey plan number, BK numbers, whatever, drawn on survey plan number. This is the property we are talking about.
Okay.
Just for to make it doubly clear that that's the property we're talking about. Then the execution clause is where everybody, the buyer and the seller, must sign. Now, if you have a deed of assignment prepared over a place that has title, there must be a clause known as the consent clause. Because the same land use act that said that the governor has all the property in the state and is a custodian says that there must not be any transfer of titled land or just transfer of land interest without the governor of that state knowing. You understand? So the governor is Yoruba balance is the Baba Isalo of everything relating to real estate in the state. So any transfer from myself to you, the governor must know. Your father to you, the governor must know. Your husband to you, the governor must know. Okay. Now that is the deed of assignment. So that consent clause at the end of the deed of assignment, especially when there's title, cannot. It must be there. Because that's where the governor will say, okay, oh, I consent to this transaction.
This paper pass through my table.
Kind of thing. So now this is another one that I have to pull out. A lot of clients for buildings they say governor's consent. Realtors, I'll tell realtors to always they must still recognize the fact that talk the language your client understands. When most clients use the word governor's consent, it's title they are referring to. What title does he have? Does he have governor's consent? Does he have seal? Governor's consent is just what the law says. The governor's consent is not the name of the title.